Welcome back to Good Law, Bad Law. My guest on today's episode is Carl Cranor. He is a professor of philosophy and also a member of the environmental toxicology program at the University of California in Riverside. And he's the author of a book called Tragic Failures. We're talking today about the intersection between science and law, particularly in the field of dangerous, even toxic chemicals and products. Imagine, as he described, he asked of his students in class one day that each of them try to count the number of germs on their desks. Try it. How would you do it? It'd be very difficult to do, actually. And that's just the most simplified example of the problems that we have with our government, which is hopefully committed to protecting us and keeping us safe from dangerous products, though in many ways the opposite of that is what actually happens. And our court system, where we'd like to think that an injured person, someone who suffered a harm from a dangerous product, can go and get redress. In each of these spheres, we find tremendous challenges in bringing science to bear on the problem of whether something is dangerous and whether that something caused harm. So we ramble our way through this topic in a way that I think you'll find interesting. And I don't know that there's a more disillusioning part of the law than this, because again, the law should be designed to protect public safety, human safety, and well-being. And there are so many ways in which the law, as Carl says at the end of our conversation, where the law has really failed us. But we need to understand how it has failed us in order to improve it and make it better. So with all that said, I will mention my standard PSAs this time of year and urge everybody to continue to be safe in your dealings. At some point, the weather's going to turn cooler and we're going to spend more and more time inside. It's all the more reason why you should be wearing one of these wherever you go and you're around people. Also, we are less than 50 days away from the election on November 3rd, so please make your plans as to how you're going to vote, whether it's by mail or in person. Just know what you're going to do, and if there's early voting in your state, or you can request a mail-in ballot, do so now, please, so that your vote can count this November. Very important for everyone. And stay tuned for this episode of Good Law, Bad Law. I want to welcome my guest on today's episode, Carl Cranor. He is a professor of philosophy and a member of the environmental toxicology graduate program at the University of California, Riverside, Southern California. So Carl, first of all, welcome to Good Law, Bad Law.
Thank you. Delighted to be here.
I am very excited, as we were just discussing before we went on, very excited to have this conversation. This is a topic, the ways in which science and law intersect, and not always to the good of the people, of consumers, in both public health law and in what you and I would agree we can call tort law, or civil cases brought in court. Why that intersection between science and law does not always work so well. And a lot about this, I think, is so important for people to understand, because we are all exposed to so many substances in the air, in the water, in our food, in products, often not even realizing we're being exposed.
Right. Well, sometimes I think to ask the question of an audience I'm addressing, how many think that substances that may be toxic are tested before coming into commerce? And most people, I think, assume, well, it's all like pharmaceuticals, and it ain't. And so we've had a terrible law with the Toxic Substances Control Act, where almost nothing got screened out coming into commerce, and then everybody has to play catch up.
Yeah. Well, yeah, that is, I think, I agree, one of the big misconceptions about toxic or potentially toxic substances, products, etc., is that we have a regulatory system, we have a government that is keeping us safe from things dangerous.
That's what people assume.
And it's for the longest time in our country's history, it has been the opposite. Whereas
Correct.
drugs, before they can come into the market and be taken by humans, have to go through trials, have to go through
Yes.
testing to make sure they're safe. And if they're not safe, they're kept off the market. But
They don't come in. Yeah.
it's complete reverse when it comes
Yes.
to things that aren't pharmaceuticals.
Yeah.
Why is that?
Well, there are actually a couple of explanations. First of all, when they passed the Toxic Substances Control Act, which is the big EPA regulatory law for governing incoming non-pharmaceutical, non-pesticidal substances, they had the 1962 amendments to the pharmaceutical laws and the 1968 amendments to the pesticide laws, both of which were pre-market screening and testing laws.
Mm-hmm.
And that's what, surprisingly, the Nixon administration proposed. That's what Congress is working on. And I don't know all the details, but I have read political scientists that indicated that when push came to shove in the final stages of approving TSCA in 1976, environmentalists, the claim was by these well-known political scientists, environmentalists were not paying much attention, and industry really was paying attention. And they didn't want to be shackled or slowed down by something like the pharmaceutical laws. They probably had, well, I don't know, maybe they didn't have, maybe they did or didn't have a misleading impression of what the pharmaceutical laws did. But we sure know what they would do for protecting the public, and industry didn't want that.
Right. Well, this is also a time when we were starting to have greater focus on the tobacco industry. I mean, the Surgeon General's warnings came out in the late 60s. It's a time when we were starting to become aware of chemical exposure. I was talking to you a bit about my own experience handling a big litigation against Roman Haas and Dow Chemical over vinyl chloride, which is in everything plastic.
Yes.
And that was just starting to come out in the 70s. The EPA wasn't even founded until 1970. So maybe we were asleep at the wheel. Consumers, consumer groups, environmentally interested groups. Well, let me take a step back before we get into some of the finer points on this topic, which is really, given that we don't have a system premised on safety first, and science and law intersect in very challenging ways to come to terms with a product or a chemical or a thing that is deemed dangerous. And what do we do about that? How did you first get interested in this? And also, as someone who comes at this from not from a law background and not even from a hard science background, you come from philosophy.
Right. Well,
so that I found that very fascinating. So how has this been? How did you come to this as a main?
That's a great question. I started out in moral philosophy, thinking about Immanuel Kant and some of his ideas, and they were Kant has a focus. He thinks the focus should be on how your principles affect individual people. He's not what philosophers would call a utilitarian that is interested in optimizing the amount of happiness or welfare that's produced by social policies and so forth. But the research I was doing, I felt wasn't going anywhere or wasn't going to pay off in the way that I had hoped. So I looked around, and this was, as you say, this was 1977, 78. The environmental movement was in full swing. And I looked around and I said, gee, philosophers are concerned about harm to others. Molecules can harm others. And so I then put together a longer term process to educate myself. First, I got a fellowship to Yale Law School. So I'm a little bit of law. I did their MSL. And so I had a year of law, but I went there specifically to find out more about legal doctrines that would help me think about exposure to toxic substances. a few years later, I sought a different fellowship and received it. I was a congressional fellow. And I sought out a location in the federal government, which is what the Congressional Fellowship does. It pays you a certain amount of money, and then you find a job in a congressional office or whatever. I started first with George Brown, who was both my local representative, but also the chair of the Science and Technology Committee in the House. But that wasn't very interesting. But as we talked, he said, well, why don't you go over to the Office of Technology Assessment? He was on the board of directors there. And so I went over and talked to them. And because I was free help, this made possible a report that they were thinking about doing, but just didn't have the resources. But I was paid for. They didn't have to pay me.
Right.
So we did the OTA, Office of Technology Assessment report on identifying and regulating carcinogens. So there was a request from a subcommittee of the House that had asked just the following question. They said, we passed all these laws to protect people from carcinogens. How well have they worked? That was our task, was to examine how well they worked and what might be done about them. Well, what we found was that, but this was perfect for my task because I'm on the West Coast. I'm very distant from Washington, D.C., and finding one's way around regulatory agencies, certainly back then was very difficult. Finding paper trails for things and so forth. So I got a lot of information. I wrote half the report on identifying and regulating carcinogens, learned a lot about risk assessment, learned a lot about carcinogens, and learned what the agencies were up to. And what we found in that report was that they had a pretty good database of animal studies that showed which things were carcinogenic and which weren't. But they had been even with that existing database in effect across a lot of agencies. I mean, this was FDA, it was EPA air, EPA water, EPA drinking water, TSCA, pesticides, and so forth. No agency had done a very good job in acting on these scientific databases that they had about animal carcinogens. And so we found that on average, they'd gotten only about 50% and this was in 1987, 86 when we finished the report, 87 when it was published, that only about half of the substances had been picked up and addressed by agencies, even though there was a pretty good scientific background. They just had been sluggish in getting to it. And of course, a lot of, I'm sure, industry opposition as well.
Well, let me make sure I understand. So in other words, there are thousands of chemicals that are used in products, that are used in all sorts of applications in every aspect of our lives. Only a handful of them have actually been studied in any kind of thorough, let alone comprehensive approach.
That is correct, but what we identified were, I believe, the federal agencies have data on about 400 substances that could be classified as a more or less potent carcinogen based on the data that they had. And even if you looked at the substances that were positive in 2 or more animal studies, which are the real indication of potency and worry, even among those, they'd only looked at about 50%. That was a much smaller universe than 400. I've forgotten now the number. Probably have a copy of a book here that would tell me. But
well, so we're getting to the issue of what it takes to prove that a chemical is dangerous, such that you can either take some action against it if you're one or more public health agency, or if you're in court alleging harm from that chemical, what does it take to prove that? That's where we're building to. And here you're saying they hadn't even gotten through half of 400 some odd chemicals, where 400 is even a small subset of the total number that's out there.
Right, and there was a
Right.
small subset where they had really pretty good animal data, and they'd only gotten to about half of those too. So their percentage of
Yeah.
use of data was slow.
Well, and you in the book, and I should mention your book, which I was reading from today. Give us the name
Tragic
of
failures.
it.
Tragic
What is it?
failures. Tragic failures. The one I said.
I was going to say dangerous failure. No, but it's called, you call it tragic. That's why I was stumbling. It's tragic
Yeah.
failures, which came out just a couple of years ago. And you actually used the word slothful to describe the way our public agencies function. That may not surprise many people to hear, but you tell the story about formaldehyde in particular. And I think that's a good illustration of exactly what we're talking about.
Correct. Yeah.
Both because of the breadth of its use in so many different things that all of us have come into contact with in one way or another,
Mm-hmm.
and how clear it is, the science of its dangerousness. Right. How does that fit into what we're talking about?
It exemplifies it to the point.
Mm-hmm.
It turns out that I looked into studies that have been done on formaldehyde by IARC and National Toxicology, International Agency for Research on Cancer, National Toxicology Program, and found that there had been about, the numbers may be off slightly, 17 studies over a 20-year period,
Mm-hmm.
where they'd identified formaldehyde as a carcinogen, mostly for nasal and throat kinds of cancers, but more recently for leukemia at IARC. And I found a story about a woman who used a hair straightening product as a beautician. She died of leukemia. Mm-hmm. And this hair product, can I remember the name of it? Probably not.
Brazilian something.
The what?
Wasn't it? Was Brazilian something?
Brazilian blowout.
There you go.
Yeah, that's right. It was loaded with formaldehyde. Yeah. She didn't know it. And she got a you might say, characteristic disease from formaldehyde exposure, which the epidemiological studies had just revealed, fairly recently revealed. And she died at, I don't know, 53 or something like that. Mm-hmm. So it exemplifies it, and it has been stuck in the integrated risk information system at the US EPA for 20 years, something like that. They've just not been able to act on it. Now, I do have a colleague in toxicology who tells me that formaldehyde is difficult because it is, to some extent, it's naturally produced. And to some extent, we come into contact in other categories, but it's difficult to determine the lowest level of exposure that would be harmful. But that begins to approach the lowest level of, that begins to approach the natural exposures. One could still deal with that. You don't want to add to the natural exposures that are out there, but right. They haven't gotten to it.
Well, right. We have natural amounts of radiation that we're exposed to every day. That doesn't mean we want to have an X-ray machine blasting our face.
Exactly right. Yes, exactly right.
But well, I mean, let's think about this philosophically then, because that gives us a bit of a different focus. From what I remember about torts in law school, and this is going back, sadly, a quarter century for me.
Oh, but you're an expert now.
You know, the underpinnings of our tort system, that is, of our modern tort system, that is the system of civil law that allows one citizen to sue another citizen in court for money damages when they've been wronged.
All right.
That other citizen could be a neighbor whose water overruns your property, or it could be a company that makes a product that caused you harm, and so on. A car that runs a red light and hits your car. I mean, there's all kinds of ways in which these are all torts, we would say. So, but the system, as I understand it, has been created around this idea of risk. and who should bear the risk of harm when harm results. And great learned judges and justices from 100+ years ago said that companies and individuals should have insurance to provide them protection from those instances where harm is caused, not necessarily through an intention to hurt somebody, but through carelessness, through negligence, in other words.
Yeah.
Right. So we put some amount of burden on the wrongdoer, on the harm causer.
Right.
And yet it does seem like when it comes to environmentally dangerous or toxic substances, we've almost put the entire burden on the person who is at risk of being harmed or in fact actually is harmed.
Certainly when one gets into court, that's how it feels, and the legal changes in 1993 with the Daubert case made that harder. But I tell students that the tort system was born to deal with macro objects, as you point out, cars, trains, flooding waters, and that sort of thing. Those are not molecules that are smaller than anything we can see. I sometimes give them an example to illustrate the idea of statistical power. I say, we're going to do a scientific study today. I want all 30 of you to do this, and we'll have 30 scientific studies. Tell me how many germs are on top of your desk. And of course, they can't see any because they don't have the power to do that.
Yeah.
So all the evidence that we have for these molecular substances is inferential, and that we can't see them. We can't have definitive. It's very difficult to have definitive causation except in unusual cases like diethylstilbestrol, because that's so unusual, and asbestos, and after that, I don't know. I guess angiosarcoma of the liver for vinyl chloride, but it's a small number of substances. You see the disease and you say, I know what did that.
Well, and those are all examples of molecules that cause a signature disease, meaning
Exactly.
Right.
Exactly.
So angiosarcoma of the liver is a kind of liver cancer. You
Right.
only see that when there's been significant exposure to vinyl chloride. Asbestos leads to a certain kind of lung cancer, mesothelioma.
Right.
That's
Exactly.
distinguishable from other kinds of lung cancer objectively.
Yes.
Otherwise, you're dealing with not only the small size of the substances that cause the harm, but other factors in proving causation, which is that
Multiple causation.
Multiple causation, right?
Yes.
Workers who are exposed to many different chemicals,
Right.
in other words, and how do you know that it was this chemical and not these others over here?
Right.
But let's separate these then. So, because there are two spheres where this comes up. One we started talking about, which are public health agencies that like to think our tax dollars are going to protect people from being harmed, not to protect companies who want to continue to sell their products.
Right.
Why? And then we'll come to court issues in a second. Why? I mean, from a philosopher, from an environmental philosopher's point of view, what do you think is wrong about the system that we have, and where do you think, on a grand philosophical level, we ought to be making a change in how these issues are approached?
Well, I think the best change would be pre-market toxicity testing and screening, as we have under pharmaceutical law and under pesticide law. I'm always fond of pharmaceutical law because that does actually seem to work pretty well. I'm less clear how well it works for pesticides because there's a lot of harms that are traceable to pesticides. That would be the best solution. And I need to talk to some people. I read in the book that you have toward the end that the amendments to the Toxic Substances Control Act, which were passed, the act itself was passed in '76. The amendments were passed 40 years later in 2016.
Yeah.
I thought that the language in that allows for the administrator of the EPA to demand certain things before products come into commerce, because there's the passage there. It says the director of the EPA has to find that a substance doesn't pose an unreasonable risk to people or the environment, taking into account susceptible individuals. Now, if that meant he has to find that there is scientific evidence that there would be no or I don't like unreasonable, no or unreasonable, only minimally unreasonable harm to susceptible individuals, that would be a much better law than what we have, because then new products would go through a screen before they ever entered commerce. The problem is that we have something like, and this is probably an underestimate, 85,000 chemical substances in the chemical registry that we know almost nothing about. So we have to do, and there's allowances in the TSCA amendments, but you know, if you just do a reasonable calculation, it's going to take a century or two to get to those, even to 30,000. Some people think there are 30,000 active products in commerce that ought to be reviewed for toxicity.
So let me make sure that's clear so people understand. So first of all, we have this law that came out in the mid '70s, the Toxic Substance Control Act.
Right.
And its purpose was to regulate potentially dangerous substances and products in commerce.
Right, and there's a footnote to that. That grew out of a presidential commission, and I've forgotten the name of it, that said we need to get away from doing experiments on the entire public with chemical substances. We know they're harmful. We're trying to repair damage after the fact.
Right.
So they were aware of what the language I would use, the risks of a post-market law, that you let things in if you don't think there's any problem with them, and then you pull them back only if you discover a problem. That's where we are. That was a recommendation from the President's Council on Environmental Quality. That's what it was, President's Council on Environmental Quality in 1970. And they pushed for a pre-market law in the Toxic Substances Control Act. And the pre-market provisions didn't survive Congress.
All right, so then as you say, 40 years later, we get an amendment to that.
Right.
And that went into effect in the first year of the Trump administration, 2017.
Yes, they got to implement it.
I'm a little.
It was passed in 2016. Right?
Yeah, I'm a little afraid to ask here, but so the way I heard you describe that amendment, the purpose of the amendment to the Toxic Substances Control Act was to add that which couldn't pass 40 years earlier, which was a pre-market testing requirement for new chemicals and toxic
That's how I read it, but I do want to talk to some people because I just participated in a conference with the University of California, San Francisco Medical School to make scientific recommendations going forward in the hopes that we have a new presidential administration. But there are people there, I must say, that do not think that language that I think could be turned into pre-market screening language does so. And so I need to pin that down. In Tragic Failures, I said, you know, look, this looks like it's pre-market screening, kind of like the pharmaceutical or the pesticide laws, although there is not specificity for what has to be done before something comes in. It just says the administrator of EPA, administrator, not director, has to find that a substance doesn't pose an unreasonable risk of harm to human health or the environment. And there's an obvious way to read that, the way I read it, I think, but that may not be how it's functioning.
Well,
so we may not have, other than the attention to susceptible subpopulations, we may not have gone very far beyond the old TSCA.
Well, and I think I can say this comfortably. It is impossible to imagine that this EPA
Oh yeah.
has, is performing any kind of pre-market screening, meaning before a new, because this amendment doesn't apply to anything that's already out there.
Exactly, right.
So this would only apply to some new entry into commerce, into the marketplace, that any kind of rigorous review is taking place. But that does.
May I give you an example?
Yeah, yeah.
So apparently, the Obama administration didn't begin to act on 600 proposals of new products that were coming in. They would leave that for the following administration. Scott Pruitt, a few months into the new administration, approved all 600 just like that. So you know they didn't undergo careful screening like pharmaceutical or pesticide products.
Well, so that then does lead to the next set of questions, I think, which is what tools do we have to establish whether something is safe, or conversely, to establish that a substance, a molecule, a chemical, in fact, isn't safe because it can be shown to cause this problem or that problem, this kind of cancer, that disease. Apparently, the EPA isn't relying on any kind of science.
I agree with that.
Which in this time, I think it's not unfair to say, fits with a lot of what we've seen coming out of Washington in the last few years, which is very anti-science. I was just watching the news today before we started talking. They're appointing somebody to a senior position in one of the agencies that's looking at climate change, and he's a climate change skeptic.
Exactly, right.
So
this may be the person that has a lot of weird views too, beyond just being anti-science, right?
And so, but the science of particularly human causation is, as you were starting to say earlier, when you're talking about germs on a desk or molecules, even in a substance we know is dangerous. I mean, formaldehyde is recognized as a human carcinogen. Even in those cases, there are enormous challenges when you intersect science and law. So why? Why is that? Why is it so darn hard? I mean, maybe we're not seeing a lot of science coming out of the White House right now, but our country is filled with many of the top scientists in the land. So without getting down to a granular level that will take us certainly beyond my comprehension, looking at things in the largest sense, what are some of the problems you found and identified as to why it is so darn hard? I know this from practical experience in my litigation practice. Almost all of my cases involve on some level intersections of science or medicine and law. But it is so hard. People think it's so easy. Oh, lawyer just shows up at the courthouse and millions of dollars later, companies are so sad and blue, but it's not that way, of course.
No, it isn't. I think there are a variety of things going on. And it's, this will be patchwork, but if you start in the mid-60s, you have the tobacco industry and a famous memo written by Hill and Noten, a PR firm, that said, look, doubt is your product, because if you can shed doubt on the science, this can help to undermine the public's view of how dangerous something is, to simplify. And what that permitted them to do was to say, oh, we're all in favor of protecting people's health, but the science just isn't there.
Yeah.
And so that approach embraced and created and embraced by the tobacco industry has spread to every company that gets sued about their molecules, I think. So you're going to run into doubt. We have too much doubt to figure out what's going on in this case. And I do write about that in Tragic Failures. So you find there is, and I'm sure you've met these people, there are people who make their living emphasizing the doubt about science. So yes, Mr. Freiwald, your expert says this, but what about this new study? Doesn't that cast some doubt on it? And then you start down the doubt rabbit hole.
Yeah.
And it makes it difficult. And judges are not very good at dealing with science. I gave a talk 10 years ago, I suppose, to California state appellate judges. Mm-hmm. And the person that invited me was actually on the California Supreme Court. And he started the discussion by saying, when we were all undergraduates, what did we do? We avoided the science and we went to political science because we wanted to go into law. And now what do we face as judges? We have to
That's right.
begin to dig into the science, and they're just very handicapped. I mean, this is tort litigation, not regulatory law, but the doubt has pervaded the science, and the defense uses it big time. Secondly, another approach might be the insistence on the most certain science before you disrupt commercial products. And thus in the book, I characterized what might be a highly certain kind of science suggested by a old-time toxicologist. He said, look, to be sure that something is a human carcinogen, you need to have several good epidemiological studies. You need several good animal studies at the same exposure level that agree with your epidemiological studies. And if you have mechanistic evidence, you've got to have mechanistic evidence showing effects at the same exposure level that you're worried about for people. And so
who made these rules?
Well, that was the title of his article was, and is it a human carcinogen? His answer was, no, it isn't unless you satisfy all these criteria. So that provided me a foil for a very highly demanding idea about the science that might be required for a carcinogen, and you don't need it. You don't need all of that. And then you combine that with the people that urge the doubting science. And so if you don't have perfect science or highly certain science, you've got doubt, and therefore there shouldn't be either regulatory action or the judge should object to it. I think I sent you another paper that's maybe worth mentioning that came out in Jurimetrics. The use and misuse of epidemiological studies in toxic tort litigation.
Yes.
I've read, so I read 80 mostly appellate cases, and judges really don't understand epidemiological studies. In fact, I was asked to write an amicus brief for the Fourth Circuit Court of Appeals. A plaintiff had thought that Lipitor caused some adverse effects. Mm-hmm. And there was a University of California, San Francisco expert that said, yeah, I think that's true. But when he got to court, he got pressed and say, can you say that your study is statistically significant to 0.05, the lowest conventional standard for human epidemiological studies? He said, no, but I looked at the data, and it is statistically significant at 0.065, so 0.015 higher, right? District court judge said, out you go.
Right.
Can't testify. So I and then a couple of people were added wrote an amicus brief to the Fourth Circuit, and I don't think it succeeded there because they're so locked into they want. So here's, and this was part of the critique, I guess, of judges in that Bradford Hill paper. They may want too certain a science, and they want simple rules. And in fact, the dean of the UCLA Law School offered that as an explanation for why judges do what they do. So if you have a human study and it's not significant at 0.05, can't testify using that information. But getting that is very difficult just because it doesn't account for picking up diseases that are rare. It doesn't account for picking up diseases when you have fairly small sample sizes. You'll get, maybe you'll get an effect, but you can't show that it's statistically significant at that extremely low level. Now, epidemiologists are not attached to this, but judges are, and the defense bar is. And so they try to insist on the quality of the evidence that at least some of them know is going to make it difficult to bring about a case in the tort law.
I think they all know. I mean,
yes.
we're you know.
I mean, you're bailiwick, right?
Well, yeah. I mean, defense lawyers are representing companies in these cases.
Right.
If it's Lipitor, it's the pharmaceutical company that makes Lipitor. If it's a formaldehyde case, you know, it's the company that's or the company that makes the product in which formaldehyde is used. By the way, formaldehyde, I believe, at least in a couple of scientific studies, has been shown to be generated through the electronic ignition process in e-cigarettes. So when you're
maybe I saw a headline about that.
Yeah, so when you're inhaling this product, you think, oh, it's safer than smoking a cigarette. Ask yourself how you feel about inhaling formaldehyde, if in fact that science bears out. Or Roundup, which has been so widely used, and it took decades to establish that glyphosate is a carcinogen, and now we have Bayer and you know, looking to settle for hundreds of millions of dollars. But it's
you know, that even that was difficult to get going because IARC made a finding that it was a probable human carcinogen, and I know people that were on that committee, and the affected companies did their very best to dismantle IARC. They didn't like the answer. So we're up against these political and social forces that sometimes people are aware of, sometimes they're not, but they can be unfortunately effective.
Well, I can tell you a story from my own experience about that. IARC is the International Agency for Research on Cancer. It's an international group of scientists, very well respected.
Among the best in the world on carcinogens.
Like everyone would say the gold standard when it comes to, is this chemical a carcinogen? And they have different levels that they'll rate chemicals that they study very closely. And they will accept comment and participation from outsiders. And I happen to know from firsthand experience in one of the cases I handled that a very respected epidemiologist from a very respected university in this country gave what was supposed to be an independent opinion to IARC as it was considering a pervasive, widely used chemical, but did not disclose that he or she, this epidemiologist who was consulting to IARC, was being paid tens of thousands of dollars by companies in that industry to testify as an expert in cases.
Right. Well,
I mean, this is a conflict, a terrible conflict.
Fortunately, IARC has cleaned up that act, I think. The previous, not the last director, but the director prior to that, Vincent James Coliano, said, I mean, he's in an organization with me, so I have a chance to talk to him once a year, but they were being overloaded with reports. He said, we may get a train car load of reports that industry wants us to go through before we decide what to do about the next thing on our agenda. So they forbade that. I think anybody that wants to submit a comment is limited to 50 pages.
Mhm.
And moreover, there are observers that can look in and listen. And I don't know how much they can anymore weigh in with their opinions, but they also cannot serve on IR committees. So some of that has been cleaned up, but that's a serious problem. That's a kind of it's industry capture. They have done a lot to capture
Well, but
IARC, and they capture EPA.
But the point you're making before is I think right, that defense lawyers who are representing companies who are being sued in a case need to establish some doubt. And the biggest hurdle for someone trying to prove that a particular chemical or toxic substance was the cause of some harm is to prove exactly that it was the cause of some harm. Causation, we say in the law.
Right.
And
or at least a contributing cause.
Right, but it has to be a significant contributing cause, and the expert who's offering scientific opinion, as you've described, giving some examples, is subjected to very rigorous probing by the judge before it ever gets to a jury.
Right.
Used to be a somewhat more relaxed probing under the Fry standard, and now is a more rigorous probing that the judge does under the Daubert standard. But in any case, one of the things I've always thought is, imagine you're that person. You tell some of these stories in your book when looking at formaldehyde or benzene and some PFOA, which is in Teflon.
Right.
Some of the other case studies that you looked at. Imagine you're that person who lost cows, in the watering hole to PFOA in West Virginia, or you get leukemia from because you were working around benzene or whatever it might be, and now you've got this horrible injury, and probably there's other people too who have had a similar injury, and even if you get together, you're going up against a company that has the money to have funded studies all along. I mean, how many citizen-funded studies are there on issues of toxicology or causation? I mean, they're pretty rare, right?
They're pretty rare. They're most likely to come up, possibly, I think this is pretty unlikely, but possibly funded by environmental groups, more likely funded through universities. But the influence of industry in funding studies that don't show adverse effects is enormous.
Right.
And I mean, I have some documents that were put out by the American Petroleum Institute on studies they were trying to do on benzene, that they wanted to do on benzene in China.
Yes.
And one of the PowerPoints in there says, well, sort of, what's in this for you? Well, what the studies will show, get this? This is a scientific study. What the studies will show is that the Occupational Safety and Health Administration for benzene at 40 parts per million year is correct, and it shouldn't be anything lower. That's what the studies, that's what we will find with the studies.
Before they start,
before they ever did a thing. That's right.
I understand how that works. Well, that's right. And the other thing is, even though the government has never required any kind of pre-market testing, we know enough from experience, mostly through litigation, that companies nonetheless do their own studies internally. I mean, the vinyl chloride industry knew that they knew about angiosarcoma and brain cancer long before that became public. The folks that make Roundup knew that it was dangerous because it came out in lawsuits.
Yep.
But they were never required to turn those over. They were never required to make them public or to publish them in a peer-reviewed journal.
And the same is true of the perfluorinated compounds from West Virginia.
Yeah.
Both Rob Bilott in his legal work and Philippe Grandjean, who is an epidemiologist who has appointments at both the University of Southern Denmark and Harvard, looked at the data, and the data showing adverse effects from those perfluorinated compounds goes way back in the 60s. Mm-hmm. They knew that perfluorinated compounds were, I may have the animals wrong, were causing serious problems with monkeys, mm-hmm. with rats, mm-hmm. and with pregnant women on their Teflon line. They had 7 women on a Teflon line, and they began to get a little bit concerned about that. And they took the women off the line too late. And I believe the 7 women gave birth to 7 children, 6 of whom had birth defects around the eye. Mm. You know, the 6 out of 7, you know, mm-hmm. we're nearly 100% here from exposures on the Teflon line. But let me go back to, I don't want to leave this if you have other questions.
No, go ahead.
But you asked what we could do. This is not terrific, but California has a warning law that requires, and there are problems in implementing it and what people make of it and so forth. But if the governor of California finds that a substance is a carcinogenic or reproductive toxicant, it has to be listed on a list of substances. There's now 900 substances on that. And that the hope is that gives people some indication when they're in the proximity of mm-hmm. one of these toxicants. I think that's hard. It's, you know, I don't know, you and I are both probably approximate to toxic substances at this moment, but we don't know anything about them. Mm-hmm. But if we were warned about a big hole in the road, we could figure that one out. We see a sign that says hole there. We wouldn't go there.
Right.
But you have a sign that says the governor of the state of California has found that there are reproductive or carcinogenic toxins in this facility or in this commercial product or in this consumer product or whatever. Now, those warning laws are not great, but it creates a public record that mm-hmm. a scientific panel has listed these things, and that can have some use. Moreover, there are automatic provisions to listing substances under the California's Prop 65 warning law. So when IARC found that glyphosate was a probable carcinogen, within less than a year, it was listed by Prop 65. They didn't have to do anything. They just have to say, IARC found they have some authoritative agencies. They have 5 authoritative agencies. And if those authoritative agencies find a toxic substance, California lists it. Now, if we had other laws like that had automatic provisions for triggering further inquiry and developing, that would help. It's not a cure-all by any means, but it's handy.
So California, unfortunately, and only California has this Prop 65, this warning.
That is correct. Yeah.
System. No other state, as many years as California's had Prop 65.
Industry hates it.
They hate it, and no other state has followed California.
So they fight it tooth and toenail. Yes.
Right. But in other countries, and again, this is an example taken from your book, they move much more swiftly. In other words, this is a problem in this country.
Yes.
This is not a problem universally. Other countries, I think it was relating to something to do with formaldehyde in your book. In France, there was some product that was, and
it was glyphosate, I think.
It was glyphosate. Oh, that's
within months, they did not sell glyphosate in their hardware stores to the general public.
Right. So it's not impossible.
No.
Theoretically.
Right.
But philosophically, it seems that it's one of the most demoralizing areas of law, I think, because another philosophical value that should underlie the law, capital L,
Right.
that we all like to think is there, is justice. And
Justice and
you talk about
protection of people's health. That's, I mean, I tell my doctor, not that I have any problems with my doctor, but I say, look, I only have one body. And I want it to last as long and be in as good condition as possible
Right.
before it quits on me.
Right.
And I think we should think about everybody's body like that. We each only have one body, and it should be protected.
Well, even though you're not a scientist yourself, you've worked around science and law for now many years and have written about this and continue to focus on this. You're working on a new book. You were telling me before we
Right.
started on chronic diseases.
Mm-hmm.
Just given what we've been talking about, I know we've been jumping around a lot on this topic, but what do you think about what we're seeing today? It seems like whether it's the science of wearing a mask during a pandemic or the appointment of a climate skeptic to an important climate policy position in the government. You mentioned Scott Pruitt, the EPA, who was finally run out of town because of
Other reasons, yeah.
more ethics problems than bad chemicals in a toxic waste dump, maybe you'd say.
Right. Nobody cared about those. They just wouldn't want him cheating on his budget.
Right. I mean, it does feel like we're in a time of an assault on science, and not to say that science has always been of pure intention. I mean, science has been perverted in history to defend slavery. It was perverted during Nazi Germany to justify, and even before, in the science of eugenics in this country. So there have been dark times of
Absolutely.
role of science
No
in our law, in our culture, in our politics. But I mean, we are in one of those times right now, it seems.
We are. In fact, we are, and you see a lot of adverse publicity because of it. So on the one hand, the Trump administration and fellow travelers, as it were, have done a lot to try to damage science. On the other hand, it's been so bad and so obvious that we get a lot of overt public discussion about it. Nobel Prize winners signing petitions to vote against Trump and the way he talks about science. Today, what did I see? Oh yes, the editor of Science, one of two premier scientific journals in the world, Science and Nature, wrote a scathing editorial against the Trump administration and the abuse of science. So we haven't forgotten it, but it's going to take a long time to clean the houses and get people in it. What this may do, and this is sociology, not philosophy, is it may motivate people to say, I want to make a difference. I want to go into science. I want to, bring about these changes. But, that's a long pathway. But I know lots of good scientists. I just spent 2 days last week talking with them. The discussion was centered at UCS San Francisco by Zoom. But they were really, obviously we would be. They were well informed, they were committed, and they were from all over the country. And they were at a variety of mostly either public interest groups or academic institutions. And they were training people. So that's a good thing. But it ain't easy.
Well, and I guess, if there's a change in administration starting next January, you can certainly put scientists who are truer to their science and truer to the importance of science in policy positions.
Correct.
Whether it's EPA, FDA, other agencies of government, CDC.
Let me add a footnote to that.
Yeah.
I think it's very important for, let's say, the potential Biden administration to get really top-notch and top-notch, first-rate, and organized heads of agencies. One of the things that just happened in this discussion last week was people say, partly in admiration, but disgust, the current head of EPA sure knows what he's doing and he knows how to get things done. So you got to put somebody in there to change a lot of those policies. They know how to make an agency run, know how to pick good people, and they need to do it. And Biden's got a team that could, I think, do a good job in this. I don't know who he has on the environmental side, but I hope he's smart enough. I think he's smart enough to seek out people that are really good in these areas so that we can make some progress on the scientific front. I mean, the virus has been just such a disaster that's very clear. But often people forget the Occupational Safety and Health Administration, which I think kills way too many people, sickens way too many people, the Environmental Protection Agency and these other things. So the focus now is on infectious diseases. That's probably going to be in good hands. I'll turn it over to Dr. Fauci or something.
Right.
But they have to do the same thing in the other scientific agencies to have successful efforts and to push science in a better direction by the federal government.
Carl, what's the focus of the book you're working on? I mentioned chronic diseases, but how are you approaching that?
Yeah, interesting. Well, for a number of years, I've been interested in a physician at Stanford. He's written papers on what he calls the compression of morbidity, okay? He's very interested in chronic diseases. There are about 5 or 6 chronic diseases that kill most of the people in the country, and they have enormous physical costs to them. But apart from the disease themselves, they make your life miserable. So if you have diabetes, you struggle. If you have bad arthritis, you struggle. So I began reading about him, and so I've got a couple of chapters where I just talk about chronic diseases because I think we don't understand that very well. But then I want to bring the toxic substances into it, and I'm working on that chapter right now, because toxic substances accelerate or exacerbate or somehow add to existing chronic diseases. I used the example of air pollution earlier. Of course, if you've got bronchitis or emphysema, air pollution is going to make it worse. But if you have heart disease and you don't have emphysema or bronchitis, but you're exposed to air pollution, your heart disease is going to get worse, or it might kill you. So there are surprises there hidden. And so the overall theme of the book is that in the early part of the 20th century, we had an analogous problem with infectious diseases. And a bunch of people effectively collaborated and got their act together. Public health officials, physicians, researchers, they cleaned up sewers, they cleaned up tenement houses in New York City, they cleaned up malarial swamps down south, and they did research. They in the mid-40s, they began to discover antibiotics, and they also began to develop antiviral shots. And so it took, one's tempted to say this, but I can't. It's tempting to say infectious diseases were defeated, except for pandemics and epidemics that come along. But they know what to do.
Tremendous progress in
tremendous progress
corralling all these different groups of specialists who had to come together to bring about these changes.
That's right. And it may not have been exactly coordinated, but it was jointly done, and it made a lot of progress. We're at the same position now with respect to chronic diseases that we were 100 years ago with respect to infectious diseases. Personal choices, bad personal choices lead to some chronic diseases. Smoking and lung cancer, drinking and liver disease, sedentary life and too much and bad diets contribute to diabetes and so forth. So physicians are in the business of preventive medicine. They tell their patients, don't do it. And that's, there's this writer by the name of this physician by the name of James Fries. He's the one that brought this to my attention, and I try to live by him. I do a lot of running and mountain climbing and things like that. But that's only part of the problem. That deals with chronic diseases. He mentions cancer, but he doesn't say anything about it. So that deals with chronic diseases where our personal choices can make a difference.
Right.
But he underemphasizes or he overemphasizes the role of personal choice, because a lot of people don't have the latitude and the resources to exercise the personal choices where they can go to a doctor and get good advice and all that sort of thing. Or there are all kinds of pressures in poor neighborhoods and that sort of thing where people start smoking and drinking at an early age, and then they're hooked, and then they live with that for the rest of their lives, and it ruins their health. So personal choices are part of the issue, but he mentions cancer, and he doesn't say a thing about it. Yeah. So, because I know about carcinogens and toxic substances, I want to propose a collaborative effort to reduce the chronic diseases in our lives through preventive medicines that our doctors can provide us, but we have to have better health care so that everybody can get that kind of preventive help. And then we have to do stuff on the regulatory side so that we cut the products down that cause cancers and other chronic or worse diseases in our lives. I mean, he doesn't make too much of neuropsychological disorders. But, we have Alzheimer's. I don't have any suggestions about Alzheimer's, but there are studies that show toxic effect between various pesticides and other substances and Parkinson's disease. So we can do something about that. Ethylene oxide, pesticides, solvents all contribute to Parkinson's disease. Most people don't know that. They think it's just a disease of old age. It may be to some extent, but I know researchers that look into it that say, look, if you look at the research here, there wasn't any Parkinson's around before about the mid-19th century. When what happened? We had the Industrial Revolution.
Right.
And we had the Chemical Revolution.
Well, I will keep an eye out for that book. It sounds like a very important read. And we will put a link to your other book, which we've talked about a few times, Tragic Failures, which looks at in much greater detail than we were able to go into today, these issues that we've been talking about.
You might think about also a reference to Legally Poisoned. I had a wonderful letter the other day. That's a little bit older, but I had a letter from a researcher at USC. I couldn't believe it. She said, "This is the best book I've ever read." Why did I just discover it? But it got really well reviewed, and that's on children, with the focus on toxic substances in children. A lot of discussion on the regulatory laws and why they don't work very well and so forth. So that's legally poisoned from Harvard.
All right, we will put a link to that as well, so people can get that and learn more. And we'll obviously include a good bit about your own background and bio and where people can go to get more information on that.
Sure.
So thank you, Carl. Carl Cranor from the University of California at Riverside. I feel like this was in many ways a philosophical conversation, although maybe it lacked a little bit of logic in its flow.
I try to be logical.
We were logical, but
can I add one more footnote? I'm sorry.
Yeah, no, of course. Go ahead.
My involvement in the Tort case, Millward versus Acuity Specialty Products, was to provide the logic for the scientific argument that had to be made there, because there were no human data. They only had animal data. They had mechanistic data. They understood what benzene did to the um, chromosomes because of Martin Smith, but they couldn't, the disease was so rare, they couldn't show an epidemiological study that demonstrated it. So the district court judge threw us out. Okay, we lost at the district court level, went to the Second Circuit Court of Appeals, and we got everything right. They understood everything. They understood the argument. They understood Martin Smith's scientific argument, and it went swimmingly well. And industry appealed it to the Supreme Court, and it didn't get accepted.
And the Supreme Court did not accept it.
That's correct.
All right. Well, I think you did send me some material on that.
I think you have the case.
Yeah. So I'll put that in as well. I think that people find that very interesting. So, Carl, thank you so much again for being on the podcast. Thank you for wandering with me through this topic, which is so rich. And like I said, it's one of the more concerning parts of the law, I think, and yet one that touches every life of every American in this country, around the world too. So
well, I appreciate being here, and I do think our legal system is broken in significant ways.
Yeah.
As a result, which we've talked about today, many of the problems with it. It needs substantial repair.
Well, we've hope that there are others who agree, and we'll work on that in the future.
Yes.
Thanks again. It was really great to speak with you, Carl. Appreciate it.
Thank you, Aaron. I enjoyed it. Happy to be here.